Okay, good afternoon, friends. My name is Ismail Shahtakhtinski. I'm the principal immigration attorney at IS Law Firm. Today is Thursday, August 17th, 2 p.m. Eastern Standard Time, New York, Washington time. And today's topic of the live stream is J-1 work and travel, summer work and travel program, what the J-1 program is, what type of J-1 visas exists, and what can J-1 work and travel students do to remain in the United States after the end of program. So, this is weekly live stream. Today, due to the conflict in my schedule, it is at 2 p.m. New York time, but typically we have every Thursday at 12:30 live stream on our YouTube channel where I briefly discuss an immigration topic, immigration news, and then I answer the questions from all our audience members. So if you joined us just now, please press like, please subscribe to our channel so you can be informed of our live streams. And again, today is August 17th, Thursday. Today, as an exception, it's at 2 p.m., but typically it's at 12:30 p.m. Eastern Standard Time. So what type of J-1 visas exist and what they're for, and what can J-1 visa holders do to remain in the United States after the end of program? J-1 is a cultural exchange program where the United States grants visas to students, researchers, professors, or other individuals who are coming to the United States for a temporary period of time for the main goal of the program is cultural exchange, so that the people from all over the world can come to the US, see the United States, to learn the culture and live here and practice or study in the United States. Now the J-1, there are three main types, which is J-1 work and travel, summer work and travel program, where the students from all over the world, thousands of students come to the United States every summer. You may see them in resorts, places, where you and your family may go to vacations. And those students, they come in here for a period of approximately 3 months. It starts from approximately May and ends in August or early September, where the students from all over the world, they come to the United States for a temporary period to be able to work during the peak season at the restaurants, resorts, hotels, and so on and so forth. And they can travel, they can see the United States during that time. And they also have 30 days grace period after the end of program to be able to travel and see the United States. Now, a lot of times as we approach the end of the season, end of the summer, these J-1 work and travel students think about planning to stay. They plan to remain in the United States, either to continue their education here in the United States, to get a new education, or they may ask for additional time as a visitor to be able to travel in the United States, stay here, enjoy United States more if they have enough sufficient financial ability to do so. Or they can apply, as I said, for student visa, student status. They may find an employer who's willing to sponsor them, or they may get involved with someone romantically and decide to build a family and get married and remain in the U.S. through marriage process. And finally, because of the things going on in the world, some of these J-1 students may be eligible for asylum, so they may decide to apply for asylum while in the United States. So the other type of J-1 visa is for au pairs. These are nannies that come to the United States to take care of children as babysitters, and they can take some kind of course of study during that period of time. And finally, third type of J-1 visa is for exchange researchers, professors, doctors, individuals who come here to practice their field of expertise in the United States. And then they also stay here for a period of about 1 year, 2 years, depending on the length of their program. Typically, these J-1 researchers and workers who come here to practice, they have 2-year foreign residency requirement, which requires them to return to their home country at the end of the program to live and apply what they learned in the U.S. in their home countries. This 2-year foreign residency requirement does not apply usually for work and travel students or for au pairs, and it's much easier for them to decide to remain in the United States if they are eligible. So What can J-1 work and travel student do in the United States after the end of program? So after the end of program, you have 30 days of grace period. Before the end of the program, or before this grace period, or during this grace period, is the deadline for you to apply for change of status. If you want to change it to, for example, a visitor status, you have to demonstrate that you have sufficient financial ability, that you have residence in your home country that you maintain, that you have someone who's taking care of that residence, and you have to have concrete plans as to what you will be doing here in the United States. The process consists of filing forms and supporting documentation with the USCIS, and during the processing of the time, you are going to be lawfully present in the U.S. You can actually start traveling and enjoying the United States during that time. The second type of visa that many J-1 work and travel students apply for is a student visa, F1. If you find a school program and education that you want to attain in the United States, you can apply for change of status from J1 to F1. You can apply, as I said, before the expiration of your program or within those 30 days grace period. As long as you found a school program, the first step is to get in touch with the university to get admitted. It can be language courses, not necessarily university, it could be college. Get admitted, get the paperwork from the school, which is a letter of admission, as well as your Form I-20. The Form I-20 is similar to the Form DS 2019 that you currently have because of your J-1 program. With that Form I-20, you can apply for change of status. And again, during the processing of your case, you will be able to stay here. And in fact, you can enroll in school because J-1 allows you to go to school. So during the processing of your F1, you can start your school program. There is also premium processing recently opened by the USCIS, where you can pay additional filing fees to the US government of $1,750. And your case will be decided within 15 days. The US government will guarantee that they will review your case within 15 days. Doesn't necessarily mean that it will be approved, but they will make a decision, or they may send you a request for additional evidence and documents. The type of evidence and documents you need to submit is, as I said, you have to demonstrate primarily that you are a non-immigrant, that you don't have at this time plans and goal to permanently remain in the U.S. So if you're planning to go to school, you have to demonstrate that you will apply that knowledge and education and degree that you're planning to obtain here in your home country, and that you have financial means to pay for it. You have residence in your home country to which you will return. Now, as many J-1 students, they have school programs in their home country. So if you're applying for a change of status, you also have to demonstrate what you're planning to do with that school. Like if you are in a university at your home country and you came to the US for summer program, it is assumed that you will go back and resume your studies in your country. But if you are not, if you're applying, for example, for a change of status to a visitor status, where you will be allowed to remain for additional 6 months, the question comes up is what you will do. I mean, how about school? Are you taking an academic break from school, or are you going to resume, or what is your plan? So you have to be prepared to answer those questions. And as I said, one of the most important points that you have to make in applying for change of status is one of the most important points you have to demonstrate is your financial ability to pay the costs of whatever the type of visa you're applying for. If it's student visa, student status, you have to demonstrate that you have ability to pay for tuition, you have finances, you have sufficient money in your bank account, or you have sufficient income of your own. Or if not, then you can use a sponsor, somebody in the United States, a friend, relative, acquaintance, somebody who is willing to support you in the US. They need to demonstrate their income, their tax return, their financial ability to be able to support you, or that they will support you by providing you living expenses or place to live, the house where you're going to be staying. So all of that gets filed at the same time. And since the time of filing, you can remain in the United States throughout the process. And if you are applying for student status from J-1, work and travel or au pair, you can enroll in school during the waiting period. Now, there is often a question that I'm asked, about 30 days for the school program to begin before you can apply, or 60-day rule. There is no such rule anymore. It used to be, but the Biden administration, the DHS, terminated that rule. So you can apply for F1 at any point as long as you are in a current status, that you have not violated your J-1 and you maintained your J-1 status and your program did not end. Or if it ended, you're still within the 30 days of grace period. At that time, you can apply. Now, if you met someone, you are getting married, this is a legitimate marriage, that person is a U.S. citizen or permanent resident, they can sponsor you also for permanent residence in the United States. If you are marrying with a U.S. citizen, whether you violated your J-1 status or whether you keep it before filing does not matter, because that's excused in the case of a U.S. citizen sponsoring spouse. Whether you have status or not, it does not matter. Similarly, for asylum, if you have basis for well-founded fear of persecution in your home country, you can apply for asylum in the United States, and you need to file it within 1 year. So it doesn't have to be before or during your J-1 status. It does not matter whether your program ended or if you violated your status. But what matters is that you have to file for your asylum application within 1 year of your entry into the United States. There are some certain narrow exceptions, and if you do have asylum case and you want to file for asylum, make sure to consult with an immigration attorney. You can get in touch with us. We provide special discounts for consultations for work and travel J-1 students. If you mention work and travel, you'll be sent a link. And you can schedule your consultation with me or with one of our attorneys online. You will be able to process and choose the time and date that is convenient for you. So as I said, the purpose of these live streams is for me to provide information to our audience, to listeners on YouTube, on our YouTube channel, and then I answer all of the questions, any questions anybody has. It doesn't necessarily has to be related to J-1. It can be related to any immigration matter, any immigration question. You can post it in our chat section. You see it on the right of the screen, or maybe bottom or left. In my case, in this streaming app, it shows on the right. So you can post any questions, and I will be happy to answer as many questions as I can during this live stream. My name is Ismail Shahtakhtinski, and I'm the principal immigration attorney at IS Law Firm. I'm a licensed immigration attorney. I've been practicing immigration law for more than 16 years in the United States. Our office is located near Washington, D.C., in Virginia, and therefore we have a lot of J-1 clients from Ocean City, Maryland, which is not far from here. But from all over the United States. We represent clients from all over the United States. All our consultations are held remotely via video conferencing, just like you're seeing me now. So, don't be shy to schedule a consultation if you're in some other state or anywhere else in the world. If you have J-1, if you're in J-1 status, or if you know someone, or if they have J-1. So you can always schedule a consultation online, and we can speak remotely via telephone, WhatsApp, Skype, or Zoom. Now, aside from J-1 work and travel, again, the same rules apply to au pairs. Those are babysitters that come into the United States to stay with the family. Usually it's not necessarily in the summer, it can be any time of the year. And those au pairs also can apply for change of status, as I described for work and travel students. For anybody who has a 2-year foreign residency requirement, usually, as I said, those are exchange workers, exchange professors, researchers who come to the United States. Those 2-year foreign residency requirements must be waived if you're applying for any change of status to work visa or to permanent residency through marriage, for example. So you'll have to go through the waiver process. But you don't have to waive your foreign residency requirement if you're applying for asylum. So if you have basis for asylum, you can file for asylum as long as, again, you file it within 1 year of your presence in the U.S. And under, there are narrow exceptions, and one of those exceptions is maintaining your lawful status. So, for example, in a scenario, let's say if you're a researcher, you came into the United States with a J-1 exchange visa, and you have been in the US for the last year and a half, obviously 1 year already passed, and now you have basis for asylum, you want to file for asylum. That falls under exception if you maintained your J-1 status. So if you never violated your J-1 status, you were in J-1 status, then you can file for asylum even after 1 year of your presence in the United States. All right, so if you joined us now, again, please press like, please subscribe to our channel. We have live stream videos every Thursday at 12:30 p.m. Eastern Standard Time, which is Washington, D.C., or many call it New York time, every Thursday, and where I answer questions from our audience. If you have any questions, please post it in the chat section. Now, today, due to the conflict in my schedule, I had to be in USCIS office for a client's naturalization interview. Once in a while, I go there in person. Typically, all of these interviews are held remotely, where attorney appears remotely over telephonic appearance or video conferencing, including even in asylum offices and immigration courts. But once in a while, the client insists on my in-person appearance, and they hire me to attend their interviews in person. So today I was at the USCIS office here in Washington, D.C., field office, and we had a successful naturalization interview. The case had a little bit of complications, and that's the reason why the client was nervous and wanted me to appear at the interview. But I'm glad everything worked out. So the client is happy. The case was recommended for approval. So if you have any questions, post it in the chat section. I will go through the questions and answer all of the questions one by one. All right, so the first question Anu is asking, do you need to file additional form with older U visa waiting for approval to get bona fide determination? I don't understand what necessarily you mean. If you file the U visa application based on because you have been a victim of crime, qualifying crime, you already have the certification, so you filed. If you have it pending, you must have filed it together with your certification. I don't think there is additional form you need to file other than the certification form and the application form itself. What is the priority date for WAWA from India if consular? I heard AOS do not follow visa bulletin, but how about consular? The consulates do follow visa bulletin, so look at the visa bulletin. I cannot memorize every priority date from the visa bulletin, but that's why the State Department publishes it every month. So if you Google visa bulletin, you'll get to the State Department's website and you will see all of the priority dates. Now, the USCIS doesn't necessarily follow the visa bulletin, but they make rules based on each month's visa bulletin, whether they follow it or not. So there is a link to that as well at the Department of State's website, and you can find all that information monthly from there. Millicent is asking, I have a friend currently detained in New York seeking asylum. How can I get an attorney for him? Well, one way to get an attorney is to contact an attorney first. So there is a link to schedule a consultation with me, and you can click that link and you will be taken to the calendar. You can choose the date and time upon availability where you will be able to get in touch with me. Basically, I will contact you. We can talk about your friend's case, all of the details of the case. I can tell you what can be done, what are the chances, what are the next steps, answer all your questions. And then if you decide or your friend decides, then they can hire me to handle their case. And also there is a way for attorneys to contact detainees through remote communication also at the detention center. So you don't necessarily have to have an attorney travel there. So they can call me and we can talk as well. And if they decide they want to proceed and hire me, then I'll be happy to help your friend. I can either get them released on bond or parole, or if not, then I can file an asylum application while they're in detention, request early hearing, and do everything I can to get his case approved. Filing asylum application, especially while in detention, is not an easy process. It requires preparing not only forms, but also a detailed written statement, gathering evidence, country condition reports to educate the judge and the government attorney on the country conditions, on the case, the information, the reasons for asylum application. So, as I said, I'll be happy to help. Now, you're not limited, obviously, to me. Now, asylum offices and immigration courts, as I said previously, allow remote attendance. In fact, many judges, specifically in New York as well, they prefer remote attendance from attorneys. So since the pandemic, the horizon for hiring immigration lawyers significantly broadened, because now you're not limited to your locality. You don't have to hire a lawyer, a lot of from your city or town or even state. A lot of times people search for immigration lawyers online, looking for an immigration lawyer near me. But if you do that, you're basically limiting yourself to only lawyers that are near you. And there may not be someone you like or you feel comfortable with. There may not be a qualified, experienced immigration lawyer who is enough experienced or skilled to be able to help you in the best way, to maximize the chances of your case approval. So, but now you can look for immigration lawyers as long as they are licensed in the United States, as long as they have experience practicing immigration law in the United States. You can look for immigration lawyers anywhere, even in the other parts of the world. If that's a U.S. immigration lawyer, but maybe temporarily on vacation or living somewhere abroad. As I said, most of our clients come from all over the world, or from different states. I represent clients in California, in New York, in Washington State, Florida, Washington, D.C., Miami, anywhere you can imagine in the United States. I have clients and cases, and I've appeared in most of the immigration courts all over the United States. And as I said, it's all done remotely via video conferencing. So the next question is, Emir is asking, will all people entering via CBP One be paroled, or there are exceptions? Emir, most of the so statistically 98% of the people are paroled. We immigration lawyers, I'm a member of American Immigration Lawyers Association, and with my colleagues, we constantly communicate, we share stories about our clients, and that's how we get most of the information about the CBP One, not in theory, but in practice. Every time a client calls me, consults with me almost on a daily basis, the client that entered from CBP One, using CBP One app recently, I asked them details of how long it took, how many days they had to wait, how difficult it was for them to register. Was there somebody offering them, services in Mexico to help them cross the border and so on, or convincing them to try to cross the border illegally and so on. And I gather all this information, and that's how I share with you guys. So based on the information that we share through American Immigration Lawyers Association with my colleagues, 98% of the cases, there are no detentions. So the exceptions for detentions are those where there is some kind of threat to national security. So it could be somebody's name matches with a name of a known, foreign agent, or somebody who has criminal history, criminal background. So in those cases, there may be detention, or it could be not just the name, but biometrics. They do these brief background checks, and if there is anything that is indicative of potential risk from this individual entering the United States, then there may be a detention, but typically there is not. So the next question I have is for Traori. How long my daughter, 7 years old, green card holder, can outside America, US, because she's waiting his mother I-130 application? That's a good question. So typically green card holders can be outside of the United States for a period of up to 6 months without having any issues. Now, if you do travel too frequently, even if it's 1 month, if you leave the US too often, you will be still asked and questioned at the border. Or sometimes people try to come back to the US every 5 months and 29 days to make sure that it doesn't raise this 180-day issue. But yes, I can see all the questions from admin. I'm just trying to answer all the questions from audience first. Okay, so sometimes people try to return right before the 6-month mark to kind of circumvent questioning, and then they're surprised that they're still being questioned at the border about the purpose of their visit and purposes of their absences, especially these frequent absences. But if a green card holder is absent from the US for more than 365 days, for more than 1 year, they will certainly probably have issues returning. They will still be allowed to enter the US, but they may lose their green card, and they may be called to immigration court to try to defend from deportation. They will have to prove that they have not abandoned their permanent residency despite this lengthy absence. But to prevent this from happening, even if you're traveling for short periods of time, but you're planning to travel too frequently, it's best to apply for re-entry permit. I am actually very surprised because many people don't even know about this, or many green card holders, knowing this, they still hesitate to apply for it, and then they run into troubles. The re-entry permit is just a beautiful thing. Re-entry permit is a document for which you can apply. It's a pre-authorization for which you can apply while you're in the US, asking for an authorization to be absent from the United States for a period of up to 2 years, and you can renew it again for 2 years, and then you may be able to renew it in periods of 1 year, 1 year. So, you can be absent theoretically for 3, 4, 5 years, even with a green card, without losing your green card. You don't even have to visit the US during that time, and nobody will question you about the length of your absence. Now, they can still question you, what was the purpose of your absence? But whatever purpose, for example, in this case you described, that this child is waiting for the mother's I-130, that's a good purpose to wait outside of US. So that can work. Again, that's not going to be a problem. Now, when we have a 7-year-old, especially in the case like this, the child is waiting for the mother's I-130 application, the reentry permit may not be, it's still helpful, but it's not going to be as vital and important as in the case of an adult. So, Traore, the short answer to your question is, I don't think they'll have a problem being absent, even if it's, long time, even if it's more than 1 year. I don't recommend doing it without a reentry permit, or at least, I would recommend to have this child return. But as I said, I don't think it's going to cause an issue because this child has a strong legitimate reason. Now, if it's going to be more than 1 year of absence for this child, you have to understand that it's not only about returning or not losing the green card, but also the child will lose 1 year from the eligibility for asylum. Because if you're absent for more than 1 year from the United States, I'm sorry, did I say asylum? I meant eligibility for citizenship. So if you're absent, if you're permanent resident and you're absent from the United States for a period of 1 year, you automatically, no matter what the reasons are, you automatically reset the clock for your citizenship eligibility. As we know, it's 5 years of wait time. In the case of a marriage with a U.S. citizen, if you have a U.S. citizen spouse with whom you lived for 3 years as they were U.S. citizens, then it's 3 years, but typically it's 5 years. Now, if this child has been absent for 1 year, then they return because they were waiting for the mother's I-130, then their 5-year period for citizenship will start from that date of return. Now, if the mother is going to be a permanent resident through the same marriage with a U.S. citizen, if this is a case of U.S. citizen sponsoring, then the mother may become a citizen within 3 years, and since the child is under 18 years old, they may automatically become a citizen. They don't even have to file for citizenship, so that eligibility clock may not apply. But you see how it's complicated. The child may already be a citizen, actually, but Unlikely, because the mother is waiting for the I-130, but once the mother becomes citizen, the child may automatically become citizen. The best thing is to do is, if you want the case-specific information, consult with me or with any other qualified immigration attorney one-on-one, because you want to make sure you navigate properly through this so that the child doesn't lose permanent residency or lose her eligibility for citizenship, for naturalization, or time for her eligibility for naturalization. Again, guys, whoever joined us, thank you so much. This is our weekly live stream on our YouTube channel, where I, immigration attorney, licensed immigration attorney in the United States, licensed immigration lawyer, member of American Immigration Lawyers Association, I answer questions from our audience, and I briefly talked about J-1 work and travel program, what they can do as the season is about to end, how they can apply for a student status, for a visitor status, or change their status to permanent residency or asylum in the United States. If you like this video, please press like, please subscribe to our channel. We post lots of videos on our channel, YouTube channel, talking about different immigration topics, news, and information and guides on how to do things. And so if you subscribe, you will be informed on all these videos and notices that are being filed, I talk almost like I'm talking to immigration office about these videos being posted on our channel. And if you have any questions, posted in the chat section, I will answer all of the questions posted there. All right, so Abu Bakr is asking, hi there, I am from Sudan. Can I have asylum because of what is happening in Sudan? Yes, Abu Bakr, there is a good chance that you may qualify for asylum, but of course it will be depending on your specific case, your specific story. Of course, it's very unfortunate and sad what's going on in Sudan, just like in many other countries. But it doesn't automatically make every Sudanese citizen eligible for asylum. So there are some nuances. You have to demonstrate that you specifically have a reasonable chance of persecution based on one of the protected grounds, which is the nationality, race, religion, political opinion, or membership in a particular social group. Now, those categories are not as narrow as their name suggests. There are many things that fit in those within those categories, and it's not as simple as black and white answer to the question. So you should consult with an immigration lawyer on your specific case, whether you can qualify for asylum or not. And as I said, I am a licensed immigration lawyer with over 16 years of experience practicing asylum law, handling asylum cases in immigration courts and asylum offices, and I will be happy to help you. You have the link to contact us here in the chat section and underneath this video. But yeah, so as I said, those categories for asylum application, those protected grounds, they are broad. For example, one of the frequently misunderstood protected grounds for asylum, the categories to apply for asylum, is political opinion. A lot of people interpret political opinion as narrow as just being a member of a political party or oppositional group, participating in protests against the government, which is not true. That's not only that. Political opinion can include many other things. It can include anything that you, as someone who, it can be anything, any action from you or any opinion that you may have shared that which disagrees or disapproves with the requests or instructions or orders from the government. What does that mean? So, for example, if you have been a government worker, or maybe you witnessed something, or you know something, and somebody told you to do something, and this person is a government worker, like a police officer, or a worker at the government entity, government agency, and you refuse to do what they asked you to do, then that can mean political opinion, even though you may not disagree with the government, you may not be disapproving the government, you may not be in oppositional groups, still your unwillingness to cooperate with the government or to do things that they're asking you to do may be a political opinion. For example, in today's context, we have war with Russia's aggression against Ukraine. And there are lots of Russian individuals who are either disagreeing with the actions of the government or let's say they're not willing to serve in the military. Now, every country has a right for mandatory military service. So just unwillingness to serve in military is not sufficient to qualify for asylum. But if that unwillingness stems from the disagreement with Russia's actions in Ukraine, and that those actions are criticized by the international community, which is in this case, then the applicant can qualify for asylum based on political opinion. So that also qualifies as political opinion. I had a case where my client had a business, and that happens a lot, not just a case, because it happens a lot in many of the authoritarian countries. But in this specific case that I'm describing as an example, my client had a business and he was approached by the individuals from the government who were forcing him to cooperate with them, to join their monopoly in the business, to be basically one of them. And he refused, and that was political opinion sufficient to grant of asylum. Or in another case, I had a client who was being asked by the government to testify, providing false testimony. That person's refusal to do so, and his actions and openness in refusing and why he's refusing to do so, that was qualified as political opinion. In another case, my client was a witness to actual government actions. He was not going to talk about this. He never actually planned to openly, but the police and those government officials thought that he will disclose it. So even though he didn't take any actions to express his political opinion, but by the fact that the government thought he will express his opinion because he knew too much, they were after him, and we got him asylum just based on that. So there are many situations where many different actions can qualify as political opinion, or can, for example, the law says if you are afraid to go back to your home country based on your nationality or race. It doesn't say ethnicity, but ethnicity is qualified, or tribal membership. If you are a member of tribe, or even if you're not of the same tribe or ethnicity that the persecutors believe you are, you still qualify for asylum as long as they're targeting you because they think you are. So, as I said, these categories are very broad. That's why consult with an immigration lawyer. I'll be happy to help you, or any other qualified, experienced immigration lawyer can help you to tell you what are your chances and what you can do. Nane Brian is asking, hello, I am from Cameroon. I was arrested in Virgin Islands for illegal entry after I had submitted my asylum. Will this affect my future immigration process? Depends on when you were arrested. So right now there is a new law which is called transit ban. It's not actually a law passed by Congress, but it's the way the executive branch of the government, the president, Biden, and his Department of Homeland Security is currently applying the law. Basically what it means is a regulation. So it's called transit ban, and the new rule says that if you enter the United States through any means other than lawfully with a visa or through CBP One, then you have a presumption that you don't qualify for asylum because you passed through other countries. So whatever other country you passed through, including Mexico, you have a burden of proving that you couldn't apply. There was no way for you to apply, or if it was not safe for you to be in that country. And it becomes very difficult. So depending on the time of your legal entry, the other issue with the legal entries now is, obviously the government is trying to criminalize it. It is criminalized. So under federal law, if you're entering the United States without coming to the border checkpoint, and going through the inspection, but you're crossing the fence, jumping the fence, crossing the border otherwise, or swimming across the Rio Grande, or passing through the desert, you are committing crime, a federal crime. And the current government began prosecuting those crimes. So traditionally, those crimes have not been prosecuted as much, but because they're trying to make everybody use CBP One, which is an orderly process, somewhat orderly process, of course, it's not perfect. They are prosecuting the illegal entries. And I am really, really shocked. I mean, in today's world where this CBP One app exists, I know it requires a long wait time. Some of my clients report to me that they have waited for weeks, 3, 4, 5 weeks. But even with that, it's still better than paying smugglers and going through those dangerous routes to enter the United States. One, because it's dangerous. Second is because you will have this significant uphill battle, this significant obstacle in the way of your asylum eligibility. Number three, you're not going to be eligible for EAD until employment authorization document until you wait for 150 days after filing of your asylum. And number four, you will not be eligible for any change of status in the U.S., including marriage with a U.S. citizen, if you enter the United States illegally as undocumented versus coming through CBP One app. Using the CBP One and coming lawfully entering the United States, even if you don't have a visa. So I am really shocked because I still see clients. I just had the consultation yesterday with one of these individuals who entered recently, just this month, and I'm shocked why they did not use CBP One. When I ask, they tell me that, they heard that it takes time, but somebody offered them to do this quickly. And that's right that it takes time. CBP One app used to work faster, but now a lot of people took advantage of it. And I assume those criminal groups, the smugglers who are, getting rich by smuggling undocumented aliens, and some of them causing significant harm to those immigrants, I assume they're also trying to sabotage the CBP One because it's cutting their bread and butter. But still, you should do everything you can to try to use the CBP One app to enter the U.S. because you will have much higher chances, better chances of staying in the U.S. or even getting your asylum granted. By law, you will have more chances. Now, this may change. This may change in the future. There is a federal court case. There is litigation on this topic, and one of the federal courts just recently, a couple of weeks ago, I believe, they struck down the law, the Biden administration's rule of the transit ban, but they allowed it to remain in force until the appeal goes on. So, it may change, that there may be no more transit ban, or the CBP One app may actually stop working if they cancel it. There is also litigation against the government currently by Republican states trying to stop the CBP One app because they're claiming that it's too open and it's too easy to enter the United States for anyone from the world, which partially is true. It's never been as easy, as simple as to enter the U.S. without a visa to apply for asylum. And those CBP One entrants, they don't get questioned much at the border, as the government promised to the United States citizens, than to the Congress, that they will be questioning. So there is not much going on. Unfortunately, there is a chance that some of the individuals that may harm the United States may enter through CBP One app. It's just based on the practice, on what I see is going on. But still, if you have basis for asylum, if you're planning to apply for asylum in the U.S., you don't have a visa or means to enter the U.S., don't try illegal entry. Use the CBP One app and do your best. All right. Kai is asking, hi, sir. Good morning. Is it possible to expedite your individual hearing and master hearing on the same day? Why are so many affirmative asylum cases referred to the court according to recent stats? Thanks. So the stats for referred cases, let me address that question first. You need to look at the perspective of the number of applications. So I haven't seen those stats, but I wouldn't say that there are too many affirmative cases being referred to court percentage-wise. It's just there are too many affirmative cases being filed. And the other factor that I think that influences is that once these asylum cases got stuck for many years, as you all know, the asylum applications were being processed within 60 days. By regulation, by law, they're supposed to be processed and decided within 60 days of filing, 2 months. And that's why the asylum officers used to do that. In old times, when I started practicing immigration law 16 years ago, we would file asylum cases and we would have interview within 45 days and the decision would be issued within 60 days. And then things got bad and everything got stuck, and it got stuck for years. So some of the asylum applicants began waiting for 2, 3, 4, 5, 6 years for their asylum interviews. And a lot of individuals who never had asylum basis saw this and some crooks and many individuals who try to take advantage of the system and of the immigrants to make money out of it. They started suggesting to file asylum applications even if you have no basis, because having your asylum case pending would give you at least 3, 4, 5, 6 years of time remaining in the United States lawfully, and you would get a work permit, and you would be able to work and live here in the United States lawfully. And then within those years, you may find someone and get married, or you may have a possibly maybe employer sponsoring you, or you may have a relative who filed a petition for you. It may take a long time. And during that time, a lot of people started filing for asylum without basis, because that was a good deal, right? I mean, I'm not blaming those individuals, but I'm blaming those lawyers. Even some lawyers started advising their clients unethically and illegally to file asylum without basis just to get by, because that kind of presented them a good opportunity to basically take advantage of the system. Why not? So these backlogs in asylum cases, the government, by creating these backlogs, by causing these backlogs due to inefficiency and under budgeting of asylum offices, created this unintended consequence where there began being a lot more fake asylum cases being filed, asylum applications being filed by individuals who really have no basis. Either they make things up, or they just filed the application even without writing any specific story or declaration or statement as to why they're afraid to go back to their home country. Or they wrote something which was, they're afraid, but it's just too general. Like, okay, my country sucks. It has corruption and, it's a dictatorial regime. I don't want to go back there. And somebody filed for asylum on those ridiculous bases. And this asylum application would sit with the USCIS for approximately 5, 6, in some cases 7 years. And this applicant would get an EAD, work permit, and be able to work in the US, live in the US for all these years. So this is what happened, and that's why there were too many either fake or baseless asylum applications filed. And that's why we see many affirmative asylum cases being referred to immigration courts, because the number of applicants have significantly increased because of these fake applications. To address this issue, in 2018, the government tried to process the newly filed cases earlier so that those baseless asylum cases would be cleared out faster, and it would discourage the new applicants from filing asylum without basis, hoping they'll get by for another 5, 6, 7 years. So the government tried to prioritize the newly filed asylum cases. And it worked briefly, maybe for about 6 months. We saw in the asylum cases being scheduled for interviews within several weeks of the filing, started with several weeks, then turned into several months, 6 months, and so on. And then it got out of hand again. And now, again, all of the asylum cases that are being filed usually fall into the backlog. Once in a while, we see an asylum case being filed where the asylum interview is scheduled within months. But in most of the cases, I would say in 95% of the cases, when we file asylum, those asylum applications are processed very slowly, and they just fall into the regular backlog, which may take years until they have interviews scheduled. So that is the reason, Kai, why you see many affirmative asylum cases being referred to immigration courts compared to the years before, when there were no backlogs, when everything was as normal as it should be. It wasn't perfect, but still, it was normal. It was much better. So now, to answer your question, Kai, about whether it's possible to expedite your individual hearing and master hearing on the same day, the answer is no, not on the same day, but it's possible to expedite. And what you should do, or your lawyer should do, you should have, first of all, you should have a lawyer if your case is an immigration court, okay, period. I don't care how knowledgeable, skillful you are. It's like having a surgery on yourself. It doesn't matter if you're a scientist, how smart you are, you cannot do a surgery. Even if you're a lawyer, and you have your case in immigration court, hire a lawyer to represent you, okay? So, but anyway, you and your lawyer, what you should do is you should waive your master hearing. You should file the written pleadings, which is basically a written form of everything that you or your lawyer would be discussing at your master hearing. You would file it in writing. So that's called written pleadings. So you should file those written pleadings, and you should file a motion to waive the master hearing. And that significantly by itself expedites your case, and the immigration judges love it. So for anybody who doesn't know, master hearing is a preliminary hearing in immigration court. So every time somebody is placed in immigration court, anybody who enters the US to apply for asylum, their case is placed in immigration court. And the immigration judge is going to have a hearing to review their case. But before they have this main hearing, trial, which we call merits hearing, and the courts call it individual hearing, before that hearing, there is a preliminary hearing, master hearing. And I expect one day they will eliminate it altogether, but they still have these master hearings. But the judges like to eliminate it. They don't like having these, hundreds of people appear in front of them for this ridiculous hearing where all they're doing is just basically, the whole point is to set up the date for the main hearing. And some of those master hearings are scheduled for years into the future. So if you come to the US through CBP One app now, you enter the US and you ask for asylum, it's likely the immigration court will schedule your first hearing in sometime in 2025. That's your master hearing. So since it's a useless hearing, what you should do, or your lawyer should do, is file your written pleadings and ask the immigration judge to waive your master hearing and to schedule your individual hearing. And at the same time as you're doing this, you should file a motion to advance, a motion to expedite your individual hearing. If you provide strong enough basis and you ask the judge in the same motion, or concurrently file the motion, there is a good chance they can schedule an individual hearing very soon. We had a case where the master hearing was supposed to be 2 years later. We filed the same motions that I just described, and the judge scheduled the hearing 2 weeks after that, the individual hearing, not the master. So the judge waived the master hearing, took upon our motion and said, okay, I'm happy to schedule it, and scheduled the individual hearing within 2 weeks. Now, that unfortunately didn't work because the government wasn't ready. So they came to the hearing after 2 weeks and they said, that's too soon. The government attorney on the other side, the immigration court, they asked for continuance, but the judge granted a continuance, I believe, for another 2 months. And then within 2 months, we had the individual hearing. We got the grant of asylum for this guy and his family. So what I'm trying to say is that there are many techniques and ways, and this is not all. There is also a way to communicate with the clerk, to try to swap cases between your colleagues. There are many ways to try to expedite your individual hearing, to terminate your master hearing, to advance your individual hearing, to file motions, to do things so that your case can go fast. A lot of times judges have windows open in their calendar because some hearing may be canceled or somebody may be asking for continuance. And if they do so, they want to fill it with something else. If your case is in front of the clerk, if you filed a motion to advance, and if you provided enough justification, they have a power to put your case on that window. And, as long as you have complete file of your asylum application filed, then they're going to be motivated to schedule your individual hearing. And that's another thing you should do, is to make sure that you have your asylum, not just the form, but your written statement. If you're using an expert opinion, your evidence for your case, country condition reports, all of that, the entire package has to be complete and full and filed with the court, and copies sent to the government before you ask to advance your case, to expedite your case. Because if they expedite it, you may not have enough time to do so, or if they expedite it, they're going to ask you if you have already filed this. A lot of times judges will not expedite, or the clerks will not expedite your case if you have not filed your complete asylum application with all the evidence, country condition report, and so on. All right. Emir is asking, if coming through the border, should I file my asylum case before 21 days through USCIS or after that via the court? What is the ideal time to file an asylum case for those who cross the border? The ideal time is to file as soon as possible. Now, an ideal time to actually prepare your asylum application package is before you actually come into the US, because at the border, if you are questioned, or if they do a credible fear interview, which is still a thing, or if they detain you for any reason, you are going to have a hard time filing your asylum application or preparing it. And you also can give inconsistent and unprepared information to the government, to the officers at the border, which will contradict with your asylum case because you were not prepared well enough. And it can confuse them, and it will stay with your case, and it will be used against you. You've seen the movies, when somebody gets arrested and they say, everything you say will and can and will be used against you. You have a right to keep silence. Everything you say will be used, can and will be used against you. That's called Miranda warning, right? So you've seen that in the movies. The same applies here in the immigration law. But here, the difference is that you don't have a right to keep silence, because if you keep silence, you will be deported, right? Because you have to file for asylum. You have to provide answers and explain why you're afraid to go back to your country. So if you keep silence, they're not going to give it. It's your burden. In the criminal case, it's a difference. It's the government's burden to prove. Here, you have to prove that you deserve asylum. So that's why keeping silence is not an option. You have to talk to them. But if you talk to them, everything you say, that part of the Miranda warning still applies. Everything you say can and will be used against you. So if you're not prepared and you're talking to the immigration officers at the border or here in the United States, and you haven't consulted with a lawyer, you're running a big chance of losing your case because of the lack of consistency between the two statements, just because you blurted something out that you were not supposed to, or you said something that sounded confusing, and so on. So be prepared. Hire a lawyer, make sure your case is ready even before you enter the United States. And once you enter the United States, you should file your case as soon as possible. If your case in immigration court is already open, you have a hearing date, and the paper that they give you at the border, it shows the hearing date, but it's not actual hearing date in most of the cases. So don't rely on that. But you should check with the EOIR case status online and check your hearing date. If you see that your case is open, then you can file it with the court. You will still have to file a copy with the immigration office for your biometrics, but you can file it with the immigration court. But if you don't have a hearing date, you file it with the USCIS, but do it as soon as possible. The earlier you do, the better it is. And the earlier you do, the earlier you will earn eligibility for employment authorization document based on your pending asylum. Okay, the geek is asking, I'm a Turkish citizen. My wife was Korean, and we divorced in Korea. We did not divorce in Turkey. Am I still legally married in Turkey? I am still legally married in Turkey. I doubt it, the geek. Many people think so, that if you divorce in one country, that divorce is divorce there. No, if divorce is divorce everywhere. I mean, at least from the standpoint of the United States. You don't repeat the marriage or divorce, just like you don't repeat the birth, right? So you were born in, it doesn't matter where you were born. If you were born, you were born. You only have one birth certificate. I am still legally married to Turkey. Should I write divorced or married on the asylum document? Of course, if you are divorced, as I said, if you are divorced with your wife, doesn't matter where, you are divorced. Whether Turkey has a weird law that it doesn't recognize divorce in another country. Again, I doubt it. That would be very difficult to believe. But even if that, you're filing this in the United States, you are divorced, doesn't matter where you married or divorced, it is still counted as marriage or divorce in the United States. Ibrahim is asking, asylum and T visa, which one is the best? Well, there is no such a thing as which one is the best. T visa is for victims of trafficking. If you are a victim of slavery, trafficking, modern day slavery, and you were brought to the United States, then you can apply for a T visa. If you have basis for asylum, you may have both. You can actually file for both. But if you have basis for asylum, then you can file for asylum. I will answer some of the more questions from our social media accounts, and we'll try to wrap it up here. But if you still have any other questions, you can post it here. I will need to wrap it up very soon. It's been almost 1 hour. Again, this is our live stream, weekly live stream on our YouTube channel. My name is Ismail Shahtakhtinski. I'm the principal immigration attorney at IS Law Firm. On every Thursday at 12:30 p.m. Eastern Standard Time, except for this Thursday, it was at 2 p.m. due to conflict in schedule. but typically at 12:30 p.m. Eastern Standard Time, which is known also as New York time, we have live stream where I answer questions from all our audience members. If you have anybody you know, your relative, friend, colleague, acquaintance, somebody who needs immigration help or who has immigration questions, they may be bothering you with questions, refer them to this account, to our YouTube channel, or to our Facebook page. This is being live streamed on our Facebook and YouTube channel. And let them know that this immigration lawyer, who is a United States immigration lawyer, licensed immigration attorney, who has been practicing for more than 16 years, answers questions from all our audience members every Thursday at 12:30 p.m. Washington, D.C. time. And if you are here, if you like this live stream, I would greatly appreciate if you press like. And if you don't like it, please post what you don't like about it. I will be happy to read. I like criticism. And if you like it, please press like. It would be amazing if everybody is watching us now pressed like at the same time. We would suddenly see uptick in the number of likes, and I will greatly appreciate it. Please also subscribe to our channel and refer your friends and colleagues and relatives. All right, so can a Canadian apply for asylum in the United States? Yes, anyone can apply for asylum in the United States except US citizens, but it's very unlikely as a Canadian you will get asylum unless you have special circumstances. Again, I don't know anything about your case. Is it possible? Yes. Is it likely? No, very unlikely. In 16 years of my practice as an asylum immigration lawyer practicing asylum cases, I've never seen or heard of Canadian granted asylum in the United States. All right. Hello, sir. I have a pending asylum case, but already have a work permit. I want to start an LLC. What option do I have for my business if asylum is denied? Anyone can start an LLC in the United States. It has nothing to do with your immigration case. If you want to start an LLC in the United States or any kind of business entity, you don't even have to be in the United States, except there are some restrictions for S corporation. Those are for tax purposes. But again, to start an LLC, you don't even have to be in the United States. If you're anywhere else in the world and you've never been in the US, or if you are in the United States, independently from your status, I can create an entity, an LLC for you, and get your company tax ID. You'll be able to open a bank account and operate your business in the US without being in the United States. Now, you cannot work for your business. You need to work permit, but you can own the business and you can hire employees. All right. What airlines can I board with expired green card? It should be all airlines, but you should consult with airlines. I don't know the specific airlines, but you should contact the airlines, because by law, even if your green card expired, you can still travel to the United States. The expiration of green card doesn't mean you lost your permanent residence. Just like if your passport expires, you're still a citizen, right? So, or if you lose your passport, you don't lose your citizenship. Similarly, if you're a permanent resident of the United States and your green card expires or lost, you don't lose your permanent residency. You're still a permanent resident. You just lost your document expired. So if your green card expired, you can still return to the United States. And the CBP at the border knows this, they will allow you. The problem you may have is the airlines may not let you board because some of them don't know, but a lot of times they do. So contact the airlines and tell them I have the expired green card and I want to do this. Somebody you're speaking to on the phone, they may not know this. Again, ask for supervisor or go to the airport and talk to the airlines agent there and tell them that I am planning to buy, Qatar Airways ticket to fly. And here I am at the airport. You come to the ticket counter and tell them, this is my expired green card. I want to make sure before I buy this that you will allow me to board the plane to the United States. And they should. All right. Okay, I got my green card in 1985. In 1986, I went back to my home country to take care of some family issues. I did visit back to USA 2 to 3 times in the next 3 years approximately. All right, is it okay to border without surveillance? Yeah, okay, I don't see the rest of this question, but you most likely lost your permanent residency. My recommendation is, if you have basis, to reapply again. All right, so we posted the link to schedule consultations with us. Again, please subscribe to our channel. Please press like. I greatly appreciate for anyone who joined this. Again, today was at 2 p.m., but every Thursday at 12:30 p.m., Washington, D.C., Eastern Standard Time, we have this live stream where I answer questions from all audience, and I briefly discuss the topic. Today's topic was on J-1 visas, work and travel, change of status, student visa, and asylum and green card for J-1 work and travel visa holders. So thank you so much for joining. Have a nice rest of the week and great weekend, everyone. Bye-bye.